This moment is proudly brought to you by Etosha Gardens. A journey of life. With every drop of water comes life. With every life comes memories. Each memory that is shared creates a legacy to be remembered. Etosha Gardens, your cemetery of choice. A very warm welcome to you, and thank you so much for joining us on Rufu, Rwakarongeka, proudly brought to you by Etosha Gardens, your cemetery of choice. Now, as was highlighted in the previous episodes, a focus on estate planning and administration. In this episode, we're proud to have been graced by the Master of the High Court, Mr. Mutasa. Thank you so much for joining us today.
Thank you for inviting me.
Thoroughly looking forward to our discussion to be able to appreciate some of the complexities in a simpler way for our audiences to understand. Maybe you could start off by giving us a brief overview on the role of the Master of the High Court of Zimbabwe.
Thank you for having me on the program. The role of the Office of the Master of the High Court is mainly to do with the deceased estates. That is the winding up and administration of an estate of a deceased person. I would say that would constitute about 70% of our work as the Office of the Master of the High Court. Why 70%? I think it's common cause that everyone dies. It's just a matter of time. And if a person dies, there's need for a systematic transition or passing on of assets from the deceased person to the survivors, whom we call beneficiaries. So because of the nature of the lives that we live, somehow we always have something to leave behind, which requires the Office of the Master to then apply the relevant laws towards the distribution of those assets which would have been left behind by a deceased person. Yeah, so other than deceased estates, the office also deals with the insolvency matters. That's another division. In this division, we deal with the liquidation of assets and also sequestration of estates of individuals. It's more like a liquidation of an estate of an individual, because if you run into debts and you have assets, but your debts are exceeding assets, you may go through the process of sequestration, your estate. Yeah, and then it's still under insolvency division. We have an exciting area which deals with corporate rescue. That is the resuscitation of companies which are going through financial distress, which are facing some viability challenges, which can be turned around in the event that the company is placed under the supervision of a person who has got potential or who has got capacity to turn around its fortunes. So I call it exciting area because we all know that in 2018 there was the promulgation of the new Insolvency Act under the Second Republic, and the main thrust of that Insolvency Act was the introduction of this corporate rescue model, which was replacing what we used to call judicial management. Yeah, judicial management also aimed at saving companies, but it did not have enough legal provisions which would compel the person responsible to turn around the fortunes of the company to act in a certain way. So it was replaced by a corporate rescue, which has clear timelines, which actually compels the corporate rescue practitioner to come up with a corporate rescue plan within 45 days of being appointed as a corporate rescue practitioner. And there are clear timelines that the process should not go beyond 3 months and so on, unless there are compelling circumstances. Yeah, so it saves jobs. And it ensures that the company continues operating, and also it creates employment in the process, because as long as the company is running and is realizing profits, it's growing. It means more hands are needed. Yeah, and those who are already within its employment will continue receiving their salaries and so forth. And that way the country grows. The economy grows as well. Yeah, so that's the other division that we deal with as the Office of the Master. And then we have what we call the Guardians Fund. Mainly it deals with unclaimed monies and also funds for minor children who do not have natural guardians, or who may have natural guardians, but the guardian may not be responsible. You see, you may be a guardian to your child naturally by virtue of being the biological father, but that does not translate into being a responsible father or guardian. So in such cases, the funds are kept in the guardians fund so that we have a controlled use of those funds for the benefit of the children. And also we have cases where we may not have natural guardians. We may have guardians appointed by the courts. In such cases, in most of such cases, we have the funds for the minor children also kept in the guardians fund. Yeah, unless if the guardian demonstrates to us that he or she is in a position to act responsibly and transparently, then we can arrange that he or she accesses the funds directly. Yeah, so, but that's a very, very important area. It's aimed at safeguarding and protecting the interests of the minor children, so that at the end of the day, they go to school, get their education, and become responsible people in our society. Otherwise, without that control, if we allow guardians to just use the funds in the manner that they want, we run the risk of having the funds exhausted before the child is even in grade 2 or grade 3. Until we know what we'll be creating, it will be a social monster.
I'm glad that you touched on managing of the funds, especially with in respect to the guardians. I do want to get back to the first reference of individuals. Maybe you could just simplify in clarifying what constitutes an estate. What is it that would comprise of an estate?
In estate, Mr. Gwaze, when you're looking at what is called an estate, we are looking at your assets, what you leave behind. It may be movable assets, that is the land, the buildings, and the other infrastructure. Then it may also be movable. We are talking of vehicles, we are talking of funds in the banks, we are talking of shares, we are talking of clothing, we are talking, it's part of your assets. We are talking of household goods. They are part of assets. And also, your estate includes your liabilities as well. They are part of your estate. You cannot, when one dies, it doesn't follow that your liabilities are extinguished. Because if you owe me and you die, I think that is a varan. No, I should get whatever you owed me from your estate. So liabilities are also part of the estate.
They do say two things in life are certain: death and taxes.
Yes, death and taxes. And we know every country survives on taxes.
Right.
Yeah.
I'm glad that you also do give that clarity. And then also looking at an interesting aspect of our discussion. Let's look at bringing relatives to the edict meeting. What if there are tensions in the family that comprise rather of some of the positions of surviving spouses, minor children, but we are aware that there are some social misnomers that can contribute towards challenges. Maybe you can expand a bit more in that regard.
It's a very interesting issue. Why? Because we've seen people making a lot of errors when they come to the edict meetings. For the benefit of the public, what we call edict meetings are meetings convened at the office of the Master of the High Court for the purpose of choosing or appointing an executor. Who is an executor? An executor is a person who is reposed with authority to attend to the winding up and administration of a deceased estate. That person will have access to title deeds, all of them. That person will have access to bank books. That person will have access to vehicle registration books, everything, insurance policies, and so on. So we are talking of a very, very important person. So when they come, the reason why we invite relatives, it's because we want to have their views. Their main relevance, so to speak, is for them to shed light on the nature of life that the deceased used to live. Because as I live with my wife, I may not tell her everything. If I happen for some reason to have a child outside with someone, I don't think it's something I can openly share with my wife or children. Right. I can choose to make it private. But in most cases, one brother may know, or two brothers, and one sister may know, or even a parent in some instances. So the whole idea of calling these relatives is because we just want to get to the bottom of the truth, which we believe can come out of these relatives, because they know certain secrets. They know certain things that the wife or children may not know. So it is at such meetings that we then get to know that, you think there are 3 children. There is 9. Right. We have 9 children, and there are other wives out there, and so on. You see. But then when it comes to the election of an executor, you spoke of tensions, and it's really common, the issue of tensions. You know why we have tensions? It's because when a person dies, right, there is, I spoke of the executor having access to banks, access to title deeds, access to everything. So the desire to have control over those things. Usually, from what we have seen in our office, the brothers and sisters, they want to have control. Right. They'll tell you it's our blood. We are related by blood. You came into our lives as Murora or as somebody, but we were bonded by blood. Right. You see. So there is always that desire to want to continue having some control. And there is that false belief that the surviving spouse may not be in a position to preserve and maintain the legacy that was left. Right. Because what always comes into the mind of relatives is that, especially if she's surviving spouse is fairly young, right, they would think she will remarry. You see, she will remarry, and then, the assets left behind by our brother will benefit this new fella who will be coming into his life. So there are a lot of things. So what they then do is, before the meeting, they will try to engage with the spouse and twist into having one of their own appointed, the brother or the tete, and so on. So naturally, the surviving spouse will refuse. In most cases, they'll say, but why? I know his stuff. I know everything about him, where he keeps his title deeds, bank cards, everything. So why should I entrust a third party? I want to
manage it on your own.
Manage the estate myself.
Right.
You see, so it then breeds tension, because they will be coming from a different standpoint. Blood is thicker than water. You know, this thing, what guarantees do we have that you administer the estate of our brother properly and so on? Yeah. So when they come to the master, we try to explain to the parties that, look, this is a family meeting presided over by the master. The whole idea is to come up with a person who has capacity to administer the estate.
I'm glad that you do raise that point. However, we will take a short break and be right back with more.
This moment was proudly brought to you by Etosha Gardens. A journey of life. With every drop of water comes life. With every life comes memories. Each memory that is shared creates a legacy to be remembered. Etosha Gardens, your cemetery of choice.